Come up, Mr. Jones.
Mr. Nalen is in Cancun until Monday of next week, Judge, so he's not available this morning.
I
So I'm kind
understand.
of filling in. I have had a chance to look at this violation report regarding missed blows. I'm assuming that's our issue here today. Spoken with Mr. Jones about that. Pressed upon him the need for perfection here.
This is no tolerance. Absolutely no tolerance, because we've had one issue after the other. Testing positive for here, doing that over there. We've literally let you go over and over and over. And there's absolutely no excuse for the missed blows. How many missed blows do we have?
It says 19, Your Honor. That's seven, within that 7 are included. But Judge, I would ask if possible, as I'm not the lead on this case, and I know Dustin has had history with the court and Mr. Jones here on this case, if you would consider holding on the consideration of this matter until he returns on Tuesday of next week. So that he can
I'm
do-
sorry, Ben, I can't. I have to know, you have to know that we mean business. I'm not here to toy with you and play games with you. Know what the expectation is in this court. You've been with me for as long as we've had. You're over there.
Because I have a cold, y'all. Cold weather. I apologize. So can I please speak on the breathalyzers?
No.
Just
You
told me
know
last
what the expectation is. You have 19 missed tests. That's it. I'm sorry, Ben, I can't. You're here and instead you're a capable and outstanding lawyer. I have the utmost respect for you, but 19 missed tests are 19 missed tests. And I've been telling
Now the pressure is really mounting. The defense is pointing out that there have been no positive UAs, but the judge is focused on something else entirely: 19 missed breath tests. From the court's perspective, compliance isn't just about whether someone tests positive. It's also about whether they follow the testing rules in the first place. And when a judge has repeatedly warned that there is no tolerance, missing 19 tests can become a major problem. The question is this a genuine scheduling issue, or is the court seeing a pattern of avoiding accountability?
missed blows, dude. Covering the camera.
Please, Honor. I will do anything. I'll even go on that drug ankle monitor. I'll do anything, Your Honor. I'm really trying here. I swear to God, I will do anything you want me to do if you just please let me stay free. I swear to God, Your Honor, I'm really trying here. Please, Your Honor. It's just I don't even drink.
From the 15th of November, you have been skipping tests. You have been to this court.
I go to sleep at 10 o'clock and I still did the ones later on when I do wake up. And they told me this just last week, Your Honor. I swear to God. I swear on everything I love.
You know
Please give me a chance, Your Honor.
testing schedule is, and I've given you one
I started
pass after the other. He goes with you. No,
Oh my God.
Your Honor, may we discuss setting a new bond for
of course.
Oh my gosh. Your Honor. Why? Please, I'm trying here. I'm trying to do everything.
Goes with you.
Oh my gosh.
Bond is at 5,001 now because of the prior violations. I'll now set it at 10,002. I'm sorry, Ben, but he's tested positive literally over and over and over. He continues to test positive for marijuana. When I've told him to stop, he's tested positive for opiates. He's tested positive for this. Now he's skipping blows. He has obscured the camera as well?
It's not necessarily that he's obscured the camera, but it's too dark to view it. It doesn't mean that there's.
It's the same thing. If we can't see you in the camera,
Yes,
then you're fooling. And I'm done with the fooling. That's it. I know that Dustin's gonna be pissed, but I mean, I've got it in black and white. And Dustin knows that it's no tolerance.
Consider 7502, Judge, for bond.
Okay, Ben. Okay, great. But he has to know that we mean business, man. If I let him go.
And there it is. The judge draws the line. The bond is being increased to $10,000. And the reason is clear. The court believes that simply letting him walk out again would send the wrong message. This isn't just about one missed test anymore. The judge is looking at the entire history: positive tests, missed tests, and alleged attempts to obscure the testing camera. But now things get even more serious because a brand new criminal case is entering the picture. and that could completely change the stakes.
Case, evading arrest in a motor vehicle, which carries up to 10 years in prison. Now you've picked up a new case. Greg, I got to tell you that I don't know how much you know, but I have quite a bit of history with Mr. Zenon here. In fact, within the last 2.5 years, 1, 2, 3, 4, 5, 6, 7, 8, 9. Now he's on his 10th case. Specifically, an unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, a felony possession of marijuana, felony assault of a pregnant person. And I guess all that worked into a deal where he got on probation for an evading. And now we have.
Right, but all those cases were dismissed, correct, Your Honor? Okay,
Pursuant to the, I guess,
I understand.
that we literally had one after the
Understand.
other, like a rung on a step ladder. One. Yep.
And-
So let's do probable cause.
Thank you, Your Honor.
You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. I just wanted to give you a heads up of how much history we have with Mr. Zenon, because it's a lot.
I appreciate that, Your Honor.
Sure.
But be that as it may,
I'm not going to hold, I've never will hold anything against him. So let's go.
On December 3rd of 2024, officers were dispatched to the HEB located at 4955 State Highway 6 regarding a disturbance in progress. Officers received 4 calls, all from witnesses who stated the defendant was arguing with and assaulting a female. While en route to the location, officers observed the couple at the intersection about 0.1 miles away from the HEB where the original call was
Observed what?
located. They saw the couple at the intersection.
Okay, they saw. Okay.
Yes, Judge. The defendant was uncooperative with officers. The defendant advised he and the complainant were involved in a verbal altercation and stated he threatened her, saying he would slap her. When officers advised the defendant that he was in custody for an outstanding warrant, he got upset and began to yell. Officers located a clear plastic bag containing 3.6 grams of marijuana. The defendant refused to comply with officers' commands to sit down and would not place his legs and feet inside the vehicle. The defendant pushed back against the officer's hand with his chest when he attempted to help him into the vehicle, pushed his legs straight and applied force toward officer's hand in an attempt to stop him from placing his legs inside the vehicle, and then used the bottom of his foot against the bottom of the door frame to further resist. The defendant refused to speak with officers and would not cooperate with the investigation. All witnesses on scene heard the defendant threaten to hit CW, and another witness stated she observed the defendant push the complainant in the chest and face with 2 open hands. He does have an active felony warrant from the Fort Bend County Sheriff's Office for aggravated assault with a deadly weapon
But he has an open ag assault somewhere else too?
in Fort Bend County, Judge.
my understanding is it's
And
an
it was
older
open
case.
warrant at that time?
Yes, Judge.
May I respond to all this, Your Honor?
Sure. Please.
Where's the interference? Okay.
Well, they're putting him in a car and he's
how-
like going
How-
blank.
It's not interference with public duties. If they're sitting there saying they have a marijuana charge they could have done, is it a resisting? Maybe,
So,
but it's not an interference with the public duties. They said he didn't talk. He doesn't have to talk to them. Like, and they're,
I understand
and
that.
they're a 0.1 mile away from the location for
So,
what?
well, okay, I get that. But so we have what we have. We've got a disturbance at HEB. Cops go there.
Okay.
They start to talk to him and I guess at that point says, hey man, I'm going to slap her. So at that point, I mean, that's what we have,
Okay.
right? Mr. Zenon, there's always 2 sides to the story. I get it. This is just probable cause. It doesn't.
Here's the key legal distinction. A probable cause hearing is not a trial. The judge is not deciding whether the defendant is guilty beyond a reasonable doubt. The question is whether there is enough evidence to justify moving the case forward. The alleged threat, witness statements, and the circumstances surrounding the arrest may be enough for that limited standard, even if the defense disputes what actually happened. And this is where the case gets complicated. Once police are investigating one incident, they may uncover other issues, including outstanding warrants or additional alleged offenses. So, what do you think? Was the judge right to let this case proceed based on the evidence presented, or did the defense raise enough questions to stop it here?